Today's video is about literally breaking news in a gun law case called Boland v. Bonta. And if you live in California, this is really exciting developments. But before we get into that, a quick reminder, the USCCA has a secret giveaway that's going on right now, and it's free to enter. And it ends really soon. So just click on the link in the description below to reveal what it is. And here's a hint, it fits in your holster. Hello, ladies and gentlemen. My name is Stephen Lieberman. I'm one of the attorneys with law offices of Lieberman and Taormina. I'm also one of the co-owners of the Artemis Defense Institute, located in Lake Forest in Southern California. Now, with that being said, I really want to talk about this case of Boland v. Bonta, and I've already gotten probably close to about 250 emails today relating to this, because it's certainly in the news. And for those of you who are unaware of what the California roster is, back in 1999, the California legislature wanted to ban Saturday night specials. Now, the reason for that is that Saturday night specials were relatively inexpensive firearms, and they did have a dubious quality. If you dropped the gun, they had high potentiality for detonating, okay? They also tended to be sold in lower income communities. So looking to try to ban these guns, they realized that they were going to run into somewhat of an issue. Not so much that they could actually ban the firearm, but that manufacturers would simply change the name from Saturday night special to Sunday night specials or something like that. So they created this scheme and they developed something called the handgun roster. Effectively, if you were a manufacturer of a firearm and you wanted to sell that firearm into the market in California through FFLs, you would have to take one of your guns, give it to DOJ. DOJ would then drop the loaded firearm to see whether or not it would detonate. Assuming that the gun didn't go off, it would then be put on this roster that was then available and certified for sale through dealer inventories. And that's really a critical component, because a lot of people have thought that the California roster created illegal guns in California, and that's never been the case, okay? The guns are perfectly legal to possess. It simply restricts what FFLs can sell out of their inventory. They're still were able to be sold in the secondary market through private party transfers or something we call the interfamilial transfer. So guns could still make their way into California. For an example, somebody could move into California, bring their firearms with them, and then subsequently, when they became California residents, they could then transfer them via private party transfers. So the secondary market for firearm sales of off-roster guns had never been affected. As a result, like I said, the guns weren't illegal. It just restricted what FFLs could sell out of their direct inventory. Well, the California legislature got really excited. After they realized that they could create this roster, they decided they would start putting additional requirements on manufacturers to get their guns on the roster. One of the requirements that they demanded was that manufacturers also include loaded chamber indicators as well as magazine disconnects. Now, a lot of manufacturers initially balked at that. Glock was a good example. Glock had Gen 1, Gen 2, and Gen 3 pistols already on the California roster. But after they got their Gen 3 pistols on, California now demanded that there be this magazine disconnect, essentially meaning that the gun wouldn't go bang if the magazine wasn't in the firearm. And Glock said, no, our users will determine whether or not a gun's going to go off, not the California legislature. So the last generation of Glocks to go on the California roster were Gen 3s, okay? Meaning that if you were to go to a gun store in California, the only Glocks that you could buy are Gen 3 or earlier, okay? even though the most firearms that Glock sells are Glocks that are upwards of Gen 6s, right? So in any event, back in 2014, there was this law that had been sitting on the books for a number of years that had been signed into law by Arnold Schwarzenegger that said, if at some future date microstamping technology becomes commercially viable, then microstamping technology will also be required to get a gun on the California roster. Well, in 2014, now Vice President Kamala Harris was our Attorney General in California, and she unilaterally made the determination that microstamping technology was now commercially applicable. And so that suddenly triggered that law. Well, here was the problem. There was no such thing as microstamping technology. She made this up out of whole cloth. So as a result, no new firearms have gone onto the roster for sale since 2014. Now, as a practical matter, advancements in technology, better firearms, safer firearms have been essentially relegated by the state of California as being unsafe, which is somewhat of an intellectually dishonest statement to make to begin with. In fact, what's also interesting is that the only way that you could have a statutorily defined safe handgun is to have a firearm that has a magazine disconnect, a loaded chamber indicator, microstamping technology, survives a drop test. There is not a single gun available on the planet that has all of those features. So by definition, every single firearm is an unsafe firearm. More importantly, the guns that are currently on the California roster are weapons that have been grandfathered. They were able to get on the roster prior to the requirements of having either a magazine disconnect, a loaded chamber indicator, or, actually all of them survived a drop test, okay? So you might have an older firearm, let's use a Glock Gen 3 as an example, okay, that survived a drop test, does not have a magazine disconnect, does not have a loaded chamber indicator, or at least one that's considered California viable, and certainly doesn't have microstamping technology. So based on the statutory definition, this is an unsafe handgun, and yet it is on the California roster that says it is a safe handgun. So, this is somewhat of an intellectual exercise, but how can you have a gun that's both safe and unsafe simultaneously? Well, you create a roster of handguns and you allow grandfathered handguns to exist. So anyways, this has been incredibly problematic, but very difficult to challenge until last June, when we had New York State Rifle and Pistol Association v. Bruin. Now we had a constitutional test articulated by the Supreme Court that we could use to challenge a lot of California's gun laws, ones that are patently unconstitutional. So one of the first ones to come down the pike was the case of Boland v. Bonta. In this case, Mr. Lance Boland, the lead plaintiff, was challenging the California roster of handguns, essentially stating that it is, in fact, unconstitutional under a Bruin analysis. Well, the case has been held in the U.S. District Court in Orange County under the auspices of Judge Kerry McCrane. And today, as of March 20th, we've had a decision on a preliminary injunction. Now, I want to get somewhat wonky on you right now, okay? We did not win the case today, all right? That would be a misnomer to say that. What we moved for was a preliminary injunction on the underlying law until the case is actually tried in court. Today, the judge agreed to issue that preliminary injunction. Now, in order for a judge to grant a preliminary injunction, he effectively needs to find two things. The first thing is that if the law is continued to be implemented, then the plaintiff our side, is going to suffer an irreparable harm. Secondly, the plaintiffs have a high probability of prevailing at trial. Well, the judge found both things. Number one, that we will suffer an irreparable harm if the roster continues to restrict the sale of these modern firearms. And number two, that we're probably going to win when this thing actually goes to trial. This is very, very exciting stuff. Okay, now, a lot of people have been emailing me today saying, can I now go buy off-roster guns? And the answer, unfortunately, is no. He didn't invalidate the roster in its entirety. The drop test, he said, actually does potentially fall within constitutional scrutiny. That might be acceptable, right? To have some government agency essentially evaluating whether or not the firearm meets certain commercially marketable standards. So the drop test is still in place, but you cannot prevent a manufacturer from going onto the roster for reasons that go beyond that drop test. That those extra requirements, the magazine disconnect, the loaded chamber indicator, and of course the micro stamping is in fact unconstitutional. So we're going to have to wait and see what happens. It's entirely possible that the state will appeal this to the Ninth Circuit. We'll have to see. It's also very possible that the DOJ will just decide to let it go the way it's going to go, figuring that this is a losing proposition. We'll have to just wait and see how this ultimately plays out. But special credit goes to the California Rifle and Pistol Association and the law offices of Michelle and Associates, who really handled all the heavy lifting on this litigation. Both of these organizations, the CRPA and the law offices of Michelle and Associates, have proven time and time again that they are really at the forefront of protecting firearms owners' rights in California, and we thank them for that. So again, thank you for watching. Definitely click on the link for USCCA below. And if for whatever reason you need anything from us, you can always email me directly through the law offices at stephen@ltccwlaw.com. You can also email me at the Artemis Defense Institute at stephen@artemis, ARTEMIS, HQ.com. As always, train constantly, train consistently, train repetitively, but always train with purpose.
Want to know the 3 biggest mistakes when carrying a handgun? Then click on the video next to me to reveal all 3 mistakes. Mistake number 2 may shock you. Everybody has their own cardinal rules for what they're going to do when they're carrying a gun, but right now I'm going to give you 3 things that you must never do